Welcome back to the Constitutional Clarion, in another video in this series discussing the Whitlam dismissal. In this video, I'll address three related claims that were made by the then Prime Minister Gough Whitlam, which have resulted in the public being misled about the legality of what occurred. Whitlam claimed that the reserve powers did not exist. The Governor-General could only act upon advice from Whitlam, and that the Governor-General could not receive advice from anyone else. All three claims were, to some extent, wrong, and in this video I'll explain why. First, let's start with the existence of reserve powers. The reserve powers are those powers conferred on the Governor-General that can be exercised by the Governor-General as a matter of his or her own discretion without the advice of responsible ministers or even contrary to their advice. The power to dismiss a government is an obvious candidate here, as it's unlikely that responsible ministers would advise their own dismissal. Importantly, the purpose of reserving these powers for the Governor-General to exercise alone is so that the Governor-General can protect the Constitution and give effect to constitutional principles and conventions when ministers may be acting contrary to those principles and conventions. For example, the appointment of a Prime Minister is a reserve power. It's exercised in accordance with the convention that the person appointed Prime Minister is the person who commands, or is most likely to command, the confidence of the House of Representatives. If, hypothetically, Tony Abbott, on losing the leadership of his party to Malcolm Turnbull, decided that he really did not like Turnbull, and before Abbott resigned as Prime Minister, if he'd advised instead the Governor-General to appoint, say, Barnaby Joyce as Prime Minister, or even Rupert Murdoch, the Governor-General would have been utterly entitled to ignore that advice and appoint the new Liberal leader, Malcolm Turnbull. And this is because Turnbull was the most likely to command the confidence of the lower house, and the outgoing Prime Minister had no power to give conventionally binding advice on the matter, because it's a reserve power. The journalist Paul Kelly stated that 20 years after the dismissal, he asked Whitlam whether he believed in the reserve powers. Now, to me, as a constitutional lawyer, that's a rather bizarre question. It treats the reserve powers as if they are the Easter Bunny or the Tooth Fairy, some kind of illusory creature that is a matter of belief rather than fact. Reserve powers have long been exercised at the federal level, including the refusal of dissolutions, the appointment of prime ministers, and, in one rather bizarre case, the termination of the commission of a prime minister, Harold Holt, who was presumed, but not confirmed, to be dead. They had also been exercised at a state level to refuse the prorogation of Parliament, to force the resignation of premiers, and to dismiss governments so that an election could be held. As a person who's written a book of over 900 pages on the reserve powers, which is called The Veiled Sceptre, I can assure you that they do exist, not only in Australia, but in many other countries that use the Westminster system of responsible government. Back in 1995, Whitlam responded to that question by saying that he did not believe in the reserve powers. In Whitlam's memoir, he stated, "It's absurd to suggest that the Governor-General is exercising in the Queen's name powers which she does not possess and would not presume to invoke." Now, this is wrong on many levels. First, the Governor-General almost always exercises powers that are not conferred on the Queen. These include the powers conferred on the Governor-General by statutes, as well as the Constitution. The Governor-General may be the Queen's representative, but that does not mean that the powers the Governor-General exercises, including those conferred upon him or her as Governor-General, must be able to be exercised by the Queen. Second, even though the monarch has not exercised, publicly at least, some reserve powers for a long time, such as the power to dismiss ministers, this does not mean that those powers have ceased to exist. Dismissal is an extreme act that arises in extreme circumstances. If those circumstances do not exist, then there's no need to exercise the power. this doesn't mean that the power has ceased to exist. On the contrary, the existence of the power makes it more likely that governments will behave in a moderate manner so that the circumstances for their dismissal do not arise. Third, the reserve powers have evolved differently in Australia than they have in the United Kingdom, and have been exercised more frequently in Australia than they have been in the United Kingdom. Fourth, Whitlam should not be presuming whether the Queen would ever have invoked such a power. It would have been a matter for the Queen's discretion in the United Kingdom, just as in this case it was a matter for the Governor-General's discretion alone. The other point to make is that if Whitlam genuinely believed that the reserve powers did not exist, then why was he constantly referring to the possibility of their exercise, including the risk of his own dismissal? It was Whitlam who told Kerr that the only way a general election would be held would be if Kerr dismissed him. It was Whitlam's office that was briefing the press about wargaming scenarios concerning his potential dismissal, as discussed in a previous video. It was Whitlam who, when warned by people, including his treasurer, Bill Hayden, that Kerr may dismiss him, who responded that Kerr didn't have the guts, not that he didn't have the power. For all the huff and puff by Whitlam that the reserve powers didn't exist, this was really just for propaganda purposes. He knew perfectly well that they did exist and that he was at risk of dismissal. But it served his purpose better if he could convince people who knew nothing about the Constitution and the reserve powers that these powers did not exist and that the Governor-General had acted unlawfully and unconstitutionally. It created a narrative, much of which has been effective and has stuck. But let's go back to basics. What does the Constitution say about the reserve powers of the Governor-General and when the Governor-General has to act on ministerial advice? Some people say that the reserve powers are not written down or contained in the Constitution, but that's not quite right. Section 5 gives the Governor-General the power to dissolve the House of Representatives, and hence the power to decide not to dissolve the House. Section 64 gives the Governor-General the power to appoint ministers, which includes the Prime Minister, and says that they shall hold office during the pleasure of the Governor-General. This means that they can be dismissed by the Governor-General. The Constitution gives the Governor-General the power to assent to bills, quote, according to his discretion, unquote. Section 5 also gives the Governor-General the power to prorogue and to summon Parliament as he thinks fit. But the response will then come that the Constitution does not specify when the Governor-General has to act upon ministerial advice or can act by exercising these powers as reserve powers, that is, without or contrary to ministerial advice. However, the Constitution does deal with that too, to an extent. Where the framers of the Constitution intended that the Governor-General must exercise a power on ministerial advice, they specified in the Constitution that the power was conferred on the Governor-General in Council. Now, what that means, according to Section 63 of the Constitution, is that the Governor-General acts with the advice of the Federal Executive Council, which is comprised of ministers. For example, under Section 64 of the Constitution, while the Governor-General can appoint ministers without advice of the Federal Executive Council, only the Governor-General in Council may establish government departments. Under Section 72 of the Constitution, only the Governor-General in Council can appoint judges, or indeed remove them, but for removal that also requires an address from both Houses of Parliament. Most significantly, Section 32 of the Constitution says that the Governor-General in Council may cause writs to be issued for general elections of members of the House of Representatives. This is important because it means that if the Governor-General exercised an independent discretion to dissolve the House of Representatives, as Section 5 confers this power on the Governor-General alone, the Governor-General could not then follow through with an election because the writs can only be issued upon the advice of the Federal Executive Council. The consequence of this is that the Governor-General cannot personally impose an election other than by dismissing the Prime Minister and appointing as Prime Minister someone else who will then advise both the dissolution of Parliament and the issuing of the election writs. So yes, the Constitution gives the Governor-General the power to appoint and dismiss the Prime Minister and to refuse a dissolution, and allows these powers to be exercised without a requirement for the advice of ministers in the Federal Executive Council. There can be no doubt that the powers exist as a matter of law in Australia. Whether, when, and how it's appropriate to exercise them is another matter. As I said before, they should only be exercised to give effect to the Constitution, constitutional principles such as the rule of law, the separation of powers, responsible government and representative government, and the conventions that flow from those principles. People may legitimately argue that their exercise in a particular case was wrong because they were exercised too early or without warning or inconsistently with convention. But they cannot legitimately argue that the powers do not exist or that the Governor-General has no discretion and must only act upon the Prime Minister's advice. Whitlam, of course, also tried to bully Kerr by saying publicly, including in a television interview on the 17th of October, that the Governor-General had no alternative other than to act upon the advice of the Prime Minister. Whitlam saw himself as Kerr's intellectual superior and his relationship with Kerr as one of master-servant, with Whitlam being the master and Kerr being there to serve him, acting only as instructed by Whitlam. He treated Kerr as an automaton with no power of his own. Whitlam sought to cut Kerr off from any different view, telling him that he could not discuss matters with the Chief Justice or anyone else. He asserted that it was improper for the Governor-General to take advice from anyone but himself. Again, this was wrong because it fudged the meaning of advice as it applies in two different ways. Buckingham Palace used to draw the distinction between what it called capital A advice and small a advice. Capital A advice is the formal ministerial advice upon which the monarch or vice-regal officer acts, such as advice from the Executive Council. That is the advice from responsible ministers to exercise legal powers, such as making a regulation, appointing a person to a statutory office, or dissolving Parliament. Neither the Chief Justice nor the opposition leader nor any constitutional lawyer or academic can give that kind of formal capital A advice. So in that respect, Whitlam was quite right, and no one disputes that. But the Governor-General is perfectly entitled to receive small a advice, which is just ordinary personal advice that any of us could receive from anybody else. Such advice has no legal or conventionally binding status. It's no more than advice, or perhaps more correctly, information and opinion, which might help a Governor-General to be better informed in making his or her own decisions. Now, as someone with expertise in the subject of the reserved powers of vice-regal officers, I am from time to time asked for small a advice. Now, this occurs usually when a vice-regal officer is preparing himself or herself for a potential crisis, such as an election that results in a hung parliament, and wants to be well informed so that they can make appropriate decisions. Now, in such cases, I would explain the relevant constitutional provisions, the relevant constitutional principles, the conventions that give effect to those principles, and a variety of pertinent precedents. I'd help the vice-regal officer to look a few steps ahead. If you do this, and they respond by doing that, what do you do then? Here's how doing that proved problematic on 3 different other occasions in the past. Now that's the type of advice that I give. I never advise vice-regal officers on what they should do. That is strictly a matter for them. The Constitution gives that discretion to them, not to me. So I only help them to be better informed so that they are well equipped to make the decision. There's nothing improper in them asking for or receiving such assistance. Now, prior to 1975, the consistent practice was for governors and governors-general to consult the Chief Justice on such matters. I'll do a separate video on that, but I just point out here that every time I read vice-regal letters from before 1975, they always refer to the Chief Justice as their, quote, constitutional advisor, unquote. In the letters I was recently reading in the Royal Archives between Governors-General and the Palace, I saw, for instance, a Governor-General excusing himself for failing to consult the Chief Justice on a potential constitutional crisis by explaining that the Chief Justice was away in Western Australia at the time and couldn't be contacted. In 1975, the consultation of the Chief Justice, Sir Garfield Barwick, was controversial because he had previously been a Liberal minister, so could potentially be regarded as politically biased. But that was also true of quite a few Chief Justices in the past, and no one batted an eyelid then about such consultation. The assumption was always made that judges could put aside their political views and give small a advice in a legally correct manner. To be clear, any such advice does not amount to capital A advice. It did not authorise the Governor-General to perform any legal action, nor did it amount to an advisory opinion of the court. It was just small a advice that helped a vice-regal officer be better informed of constitutional matters when they made their own decision to exercise their own powers. Whitlam's assertion that it was improper for a Governor-General to seek or receive such small a advice from a Chief Justice or anyone else was just something that he made up at the time. It had no basis in Australian constitutional history because such advice was frequently sought and given, and vice-regal officers felt the need to justify themselves if they did not ask for such small a advice. Sir Paul Hasluck, for example, who was the previous Governor-General, wrote about it being appropriate to seek such advice, and he did so on a number of occasions. No one complained then. So, in conclusion, despite the fact that many people still believe the propaganda that the reserve powers do not exist and that the Governor-General could only ever act as advised by the Prime Minister, this has never been the case. It's no more than a political assertion made to suit a particular political narrative and something we should therefore be quite wary of. Thank you for watching the Constitutional Clarion, and join me next time for a video about the dismissal of individual ministers during the Whitlam government and the effect advice about that later had on the dismissal of the Whitlam government itself. See you then. Goodbye.